If the allegations are false, and you know that they're false, then you know that there won't be the evidence, true evidence, to support those allegations. Why not show them to be false by establishing them as a fact? Put the issue to rest. Hello and welcome to this episode for the Survivor Diaries. This episode is about what to do if you have received allegations of domestic abuse. It may be either of the co-parents, so you could be a mother receiving allegations of domestic abuse in response to your allegations or for its own merit, and you could be obviously a father receiving allegations of domestic abuse. What I've seen and what I've been contacted about a lot of times is the presumption or this suggestion that somehow fathers are responding to false allegations of harm, and that there is this ability of mothers to manufacture evidence to have them wrongly found to be abusive, and that this has somehow stopped them from being parents of the children. This is something that I want to address in this short episode. This is what to do if you have received domestic abuse allegations against you. I have looked at other videos explaining different things or different strategies by legal professionals, non-legal professionals, what to do if you are in receipt of domestic abuse allegations. One thing that I've noticed is that these videos are primarily aimed at men. The allegations are assumed to be made by lying mothers. The overriding assumption is that the allegations are false, and therefore, flowing from that, there is obviously nothing on these videos about what to do if the allegations are true. So this video can be watched by men or women, anybody in receipt of allegations of domestic abuse, or anybody making allegations of domestic abuse. This will just recap for you the procedure, and we're going to look in some detail about the importance of the fact-finding hearing in this episode. So we'll put it in context first. We're talking about allegations of domestic abuse in private children law, so that's usually between the parents. And just a couple of disclaimers: I am a solicitor in England and Wales. I'm a family lawyer, so any very general advice or any detail about procedure applies to this jurisdiction only. So if you're outside of England and Wales, this will not necessarily apply to you. Also, always disclaiming that I give very general advice in these videos. There's nothing that can beat taking specific legal advice about your own unique situation. And there are plenty of places where you can get free advice. A lot of solicitors offer free half hours, Citizens Advice Bureau, Rights of Women. There are other groups offering legal advice as well. This is happening in private children law between the parents, where one parent has made an application to the family court in England and Wales. The first place where the allegations of domestic abuse is likely to appear is on a form called C1A. Now, for C1A and for the actual procedure itself of domestic abuse, child arrangements proceedings when there's been domestic abuse, please look at an earlier episode that we've done, child arrangements without abuse allegations, child arrangements with abuse allegations, so you can see the pathway that this would normally take through the proceedings. The C1A is either attached to the C100 application for a child arrangements order, and it's therefore the allegations made by the applicant, or it's sent in response to that application with Form C7, which is responding to the allegation, the acknowledgement that the proceedings are ongoing. So Form C1A, allegations of domestic abuse or harm, has been made, and this is where you see the first indication of allegations of domestic abuse, perhaps. So the first thing to ask yourself at this stage is it true? This is the first question that you should be asking yourself as a litigant in person. Personally, I believe that as a solicitor, it's the first question you should be asking of your client. Is it true? What's the evidence for the truth or otherwise of it that you have? Because, well, why is that important? It's important because the allegations, if the child arrangements procedure goes down the practice direction 12J route, which it should do, it would incorporate this thing called a fact-finding hearing, which we're going to talk about in this episode. The detail and scrutiny given to evidence at this stage of the proceedings, in my mind, is what makes the family justice system work. But it has to get onto this route. Now, it could be that fact findings take a day, they could take several days, even a week, a whole week of court time, looking at in very fine detail at very fine evidence. This can include expert assessments, medical records, letters from professionals, text messages, all kinds of things that will be absolutely scrutinised. And this, in my mind, is where the courts get it right. And this is where, if there are allegations of domestic abuse that are true, this is where they will be shown. Similarly, if there are allegations of domestic abuse which are false, this is also where it will be shown. So I have no conflict in working with a person who is experiencing domestic abuse or a person who is alleged to have perpetrated domestic abuse, because my first question will be always about the truth of the situation. It does startle me. There are people who do it. I see this if we're making allegations of abuse, I'm quite startled by the fact that the abusive personality will give wrong information to their solicitor. They'll pay hundreds, thousands of pounds in solicitor's fees giving that solicitor the wrong information, and therefore the advice that they receive from that solicitor is also going to be wrong. It flows, if the information is wrong, the advice that you get about what to do will also be wrong. Nevertheless, a characteristic of the abusive personality is to lie and is to push forward with a kind of bluffing, no, it never happened, there's no evidence for that, and quite often this is where it comes unstuck in the fact-finding hearing. So one of the things, as well as is it true, is to check if you understand what domestic abuse is. It's not just physical violence. The definition of domestic abuse is extremely wide, and we look at Practice Direction 12J, paragraph 3, which I'm hoping will flash up on the screen now, sets out a very wide definition of domestic abuse. It includes any incident or pattern of incidents of controlling, coercive or threatening behaviour, violence or abuse between people of 16 years of older who've been intimate partners or family members, regardless of gender or sexuality. It can encompass, but is not limited to, psychological, physical, sexual, financial or emotional abuse. It includes the culturally specific forms of abuse, and you've got forced marriage, female genital mutilation, honour-based violence, etc. And then it goes on at this paragraph to define the different terms. So coercive behaviour is defined, harm or impairment to development is defined by, for example, with children, it's how well a child of the same age in the same situation, minus the domestic abuse, would be developing. So they're measured against a standard or a norm that's usually common in schools anyway. Ill treatment includes forms of abuse which are not physical, and harm can also, this is an important one, harm can also mean the ill treatment, for example, the impairment suffered from seeing or hearing the ill treatment of another by domestic abuse or otherwise. So that's when children witness domestic abuse, and when they witness one parent being bad-mouthed by the other parent, for example, which causes a lot of conflict for them. They're too young to be able to understand the complex dynamic of domestic abuse, and instead they can only feel hurt and confused that a parent that they love is being put down or bad-mouthed by the other parent. In addition, that will cause later problems, lack of authority for the abused parent, the children may be picking up the same abusive behaviours of the abusive parent when they are not getting their own way, for example. And it's a learned behaviour, isn't it? Domestic abuse, it's a learned behaviour which we learn from our parents. So what to do if you don't know if you're abusive? First of all, I refer constantly to a book called Living with the Dominator. This is a book by Pat Craven, who's also designed the Freedom Programme. The Freedom Programme is based on a character that she has studied and been able to label with these abusive characteristics, such as being the bully, the jailer, the bad father, the persuader, the liar, the sexual controller, the king of the castle. This is the patriarchal, abusive male in her book, and how they do different things to try to control women. This is a very patriarchal age-old idea. Go back 100 years, look at Downton Abbey, you can see the difference between men and women and their standing in society. So that kind of explains where the domestic abuse that I'm talking about comes from. This is about how to understand if you are abusive. So look at the pictures of the Dominator. Look at Pat Craven's pictures of the friend, which I'm hoping we flash up as well. Which one are you more relating to? The Freedom Programme does do a short course for men, which is helping men to understand abusive behaviours and the impact that they could have on people around them, as well as that where the abusive behaviours come from, which is of course very helpful in addressing the problem or changing the problem. As well as that, you've got places like Respect UK. They offer a men's advice line, and it's possible to talk to people about the allegations of domestic abuse. If you don't think that they are abusive behaviours, you can see what happens when you talk to another domestic abuse agency or organisation working primarily, in this case, with men. What happens in the child arrangements proceedings when there's been allegations of domestic abuse from one parent to another? So I'm going to refer you to an earlier episode. Again, I've mentioned these before: child arrangements without domestic abuse allegations, and child arrangements when there have been domestic abuse allegations, to see the procedure. Critically, the court will want to determine if the allegations affect the child arrangements first. So, for example, if it's something that happened many years ago and there has been contact between the children and the abusive parents since then, the court is likely to think that the abuse does not impact on the child arrangements or should not impact on the child arrangements. In that situation, if there are ongoing difficulties, identify those ongoing difficulties that have been raised certainly since a previous hearing, or certainly since the contact resumed. If the court will want to look and see if the domestic abuse is what they will call historic or not relevant to the issue of the child arrangements. Assuming that they are convinced that it is relevant to the child arrangements, that the children are being harmed by the actions of one parent towards the other, then the court will need to determine the truth of those allegations, obviously if they are denied. In some cases, one parent will acknowledge and accept that those things have happened, and obviously the court does not need to make findings in that situation. So, what is a fact-finding hearing? This is a separate hearing within a set of proceedings. So it's a small mini set of proceedings where the parties will be ordered to set out the allegations, file statements and evidence in support of that, and then there will be court time in the way of hearings where both parties will give evidence and the matter will be judged solely on the issue of whether or not those disputed facts are true or not. So they establish the facts of the case. It looks very, very carefully at the evidence to determine whether or not it's true. And I will say that this is where I think the family court gets it right. I cannot think of a fact-finding hearing where I think that the judge has not given incredible consideration to the evidence and usually come up with the right outcome. The standard in fact-finding hearings is called the Balance of Probabilities. Now that's the standard of proof or the burden of proof. And compare this with the criminal courts, where you understand, and you've seen on TV and in criminal courts, that the burden is beyond reasonable doubt, because we're depriving someone of their livelihood or their liberty, and therefore that has to be a high standard to have such an invasive effect. In the family court, it's all very private and it's on the balance of probabilities. And this lower threshold is because we need to keep people safe. And in these cases, child arrangements proceedings, we need to keep children safe. So it's on the balance of probabilities. A very common question that I get and that happens within child arrangements proceedings is where there are current or ongoing criminal proceedings at the same time. And this does happen frequently. There may be an incident that triggers the breakdown of the relationship that also involved the police, and then there are subsequent criminal proceedings ongoing. Criminal proceedings, the police make the case, they put it to the CPS, the Crown Prosecution Service, who will decide if there's enough evidence to proceed, and to that standard, beyond reasonable doubt. Okay, have we got this person beyond reasonable doubt? And then they will take it to trial. If the person accused of the offence is maintaining a not guilty plea, then the court may wait to find the outcome of that charge. And it's quite far on in the criminal proceedings and where there's been a charge. The court may then wait for the outcome of that. If something has been found at a criminal level, so an assault took place at a criminal level. Remember, it's beyond reasonable doubt, therefore it's accepted as a certainty in the family proceedings where they're working on the balance of probabilities. So they will not have to make findings about whether or not something that the criminal court found to be true is true. They can just accept that that is. What the family court can do is that they can look at issues or allegations that have perhaps been dropped by the police due to lack of evidence. So, for example, if you have been arrested for an offence and the police took no further action because they didn't have the evidence, these things can be raised again in the family court, in the fact-finding. And the court there is looking on the balance of probabilities. Did these things happen? And that may produce a different result to the criminal courts. One very good example, in my personal opinion, of this is harassment claims, which are very difficult, or seem to be quite difficult, for the CPS to pick up on and to demonstrate. Whereas in the family court, they are identified, and the family courts will look at text messages, evidence of stalking, evidence of harassment, and they will consider the impact on that adult, on that parent, and how that would then impact on the children as well. Personally, I rate fact-finding. I rate the practice direction and the implementation of the practice direction at the earliest opportunity. So why do I think that fact-finding is always a good idea in disputed allegations? It gets to cut it short, it gets to the bottom of it. It gets to the bottom of the allegations. If allegations are dismissed or minimised by the court, and then the domestic abuse continues as a method of post-separation control, that causes harm to the children and to the other parent. Why are the courts reluctant to go for fact-finding? Well, it may be because, as we've seen recently, the court system is overloaded, no doubt about it. There is delay to the proceedings, which we don't like, and there is obviously the cost of taking something to fact-finding and having it looked at over those days. There's the cost to the court system, there's the cost to the parties. And of course, if we can't move contact on, then potentially one parent is prevented from contact with the children until these allegations are determined. We've seen, and I've referred before to a quote, I think it was in The Guardian, the family courts are running up a down escalator due to the increase in cases. Very respectfully, I think that part of the problem is that the domestic abuse issue is not dealt with at the earliest opportunity. Where domestic abuse allegations are kind of sidestepped or overlooked by the judge, then those allegations, that the problem is still there. So when the court proceedings are finished, the domestic abuse raises its head again through the form of criticism, abuse of the other parent, changing arrangements, all of the things that we know that the abusive parent will do, that just designed to make the other parent's life a living hell, basically. And this in itself obviously impacts on the children. So this is carrying on, and the arrangements ordered break down because of the domestic abuse, and the matter returns to court. And you have the same parents returning to court and returning to court and returning to court many times. We know that this happens. I know from my clients that this happens. And this is where the domestic abuse has not been dealt with at the earliest possible opportunity. I think that the problem could be solved by looking at the practice direction, robustly enforcing the practice direction as soon as you have disputed allegations. Nip it in the bud. Where the domestic abuse is not addressed, it continues through the child arrangements. That's the only way that the abusive parent can continue the abuse of the non-abusive parent, because all other ties may have been cut. The cases, if it's not dealt with, the cases will return to court, and that causes overall an even greater cost and a greater delay overall in dealing with the issue. Now that's my message, and I'm pitching that to the family justice system. It overlooks what's happening worse still, but it's perhaps not as relevant to the point of the family courts and the caseload, is that you are subjecting the non-abusive parent and any children to ongoing difficulties, ongoing abuse, ongoing stress, while it's not dealt with properly, and that's just not okay. You're carrying on with this assumption that both parents are in conflict, which is a horrifically unfair label on the non-abusive parent in cases like that. It's something that really annoys me. I want the courts to be quicker to take the fact-finding route, and I think that this was intended by the amendments to the practice direction at the end of 2017. I don't think that the case law has caught up with that yet, and I also think we're going slightly in the wrong issue. We're talking about reforming the child arrangements programme, the family courts, and how they deal with private children law cases. All that means is that we're looking at a different pathway through the child arrangements proceedings. That's fine, we can learn that. But still, the private law working group last year said that although they were looking into this, domestic abuse still need to be dealt with by Practice Direction 12J, and they actually said that they considered it timely to emphasise the integrated provisions of Practice Direction 12J, quote, forcibly remind the court of the seriousness with which it needs to consider domestic abuse in its widest sense wherever it is alleged. That's paragraph 90 of their report last year. And yet, in spite of that, there's a huge amount of pressure on the non-abusive parent to agree to some form of direct contact with the allegedly abusive parent, even though the non-abusive parent knows that that contact is harmful on any way, on a physical level, on an emotional level because of what they're told about the other parent, on a psychological level for the same reasons what they're told about the other parent. The risks are still there. So the non-abusive parent stops the contact, and the allegation that I see, the counter-allegation back on all of the videos and clips to help people with allegations of domestic abuse that I've seen, they all seem to go from the premise of mothers make it up. And I've mentioned several times in previous episodes, this just doesn't happen. Are allegations of domestic abuse ever false? Yes, they are. But it is so rare because it doesn't make any sense. When two parents have separated, if both parents were caring for the children, supporting the child's relationship with the other parent, being flexible, cooperative, working together, then the mothers that I speak to, who would turn that down? It's like in cases where contact has stopped, it's that parent then has the 24/7 responsibility of looking after the children, and it'd be nice to have a break. It'd be nice to have somebody that you can work with. It doesn't make sense. It's illogical to say that these allegations are likely to be false because they're not. So we have fathers groups saying that mothers make it up, mothers lie, say so many allegedly abusive fathers. But with or without a solicitor, what I notice is that they invariably resist the allegations being tested in a fact-finding hearing, insisting that there's nothing to the allegations, they're exaggerated, the mother has mental health issues, this is just the mother alienating the children from their father. But in doing so, what they're doing is minimising or denying the allegations and criticising the other parent for making them. The children are emotionally harmed because they can't see their father. But here's a thought. If the allegations are false, and you know that they're false, then you know that there won't be the evidence, true evidence, to support those allegations. Why not show them to be false by establishing them as a fact? Put the issue to rest. Okay, you know that this woman is making up these allegations, stopping you from seeing your children maliciously because you've done nothing wrong. And that's what you believe. You've checked the definitions of domestic abuse. You don't believe that's happening. And if you are one of the fathers unlucky enough to be in that situation and there's allegations of domestic abuse, then go to fact-finding. Show it to be false. So imagine it's gone to fact-finding. One thing that could happen is that the allegations are shown to be made up, they're shown to be false, in which case, yes, that parent has been doing wrong by harming the relationship, in this case gender-specific, of the father and the children. Of course that's wrong if the allegations are without any merit whatsoever. However, what to do if the allegations have been found? And this can also happen. So the first thing you need to understand is that many perpetrators of domestic abuse go on denying abuse even after findings have been made, or they may acknowledge it in part, saying it won't happen again. But the key point is that a lot of people maintain that no, there's no domestic abuse even after findings have been found, and that is probably an error. If you genuinely believe, not that you don't like the result, if you genuinely believe that there's been an error of fact, an error of law that's completely led to the wrong judgment, then you need to take specialist legal advice on your own situation. There's a time limit within which you must appeal the findings of a fact-finding hearing, and if you're outside of that time limit, then you very likely won't be given permission to appeal the facts. Bearing in mind that the common approach that people take after fact-finding is to say that somehow that's been got wrong. If domestic abuse has been found, the general advice that you should receive from a solicitor is to carefully consider those findings. Okay, that's now been established as the truth in the proceedings going forward, in the child arrangements going forward. And that is going to impact on your relationship with the children, the time spent with the children. Reflect on that. Speak to, if necessary, the agencies mentioned previously. So Respect UK, the Freedom Programme for Men, Men's Advice Line, obviously that's part of Respect, speaking to other people. What you need to understand is if you feel that there may be an element of truth in it, domestic abuse is a very specific gender-based problem. It's also something that is conditioned and learned through society as a behaviour without question. And people who there is support for people who genuinely want to change what they are realising is an abusive behaviour. There's support, help and understanding. Domestic abuse perpetrator programmes can take you through actual things that will help you to look at your behaviour and maybe change it differently. And that's assuming that the allegations have been found to be true and you are acknowledging those findings to be true as well. I hope that that's been useful. I am making this episode partly in response to comments on the videos, which are absolutely fine, emails saying, what about men? What about all of these men on the wrong end of allegations of domestic abuse when they've done nothing wrong? And as a general point, if you haven't done anything wrong, there won't be any evidence, so take it to the fact-finding hearing. Okay, I hope that's useful. If you do have any questions or issues that you would like me to look at in the Survivor Diary videos, please do email us. The email address should be flashing up on the screen below. I can never remember it when I'm under the pressure of recording. As I said, I hope that's been useful. Thank you once again for watching the Survivor Diaries, and I look forward to seeing you in the next episode and/or vlog. Thank you very much, and bye.